Alright, hey everybody, Nagonia Peace here, and this is a follow-up video to the other video that was titled, I believe, Accept the Deed, Title 18, Title 42, something with the county. Excuse me. So this is a follow-up video. Actually received the paperwork in the mail yesterday from the county recorder's office, where the acceptance of the deed was actually recorded. As you can see here, it was recorded, filed and recorded June 29, 2012, so forth and so on. And if you watch the other video, you know that they were giving me a lot of pushback and blocking me from recording this, of course, for various reasons, because it takes, revenue away from them. But at any rate, we got it recorded, and there's still possibly maybe some criminal actions filed. I'm not sure at this point. Giving them another opportunity to cure their dishonor. So we'll see how that goes, and I'll keep you posted on that. So anyways, this is just a simple acceptance of the deed. I titled it Affidavit of Acknowledgement and Acceptance of Warranty Deed. A couple of things in here that I feel are important is the terminology that you use. And you'll see I have underlined here real property versus real estate. Real estate is a fiction term created by the democracy entity, and it's not real. So I like to use real property. And the reason why I like to use real property, if you look in Black's Law, and the one I have is the 6th edition, it sends you over to property, and then you look under where it says real property, and the definition says land and generally whatever is erected or growing upon or affixed to land. Also rights issuing out of, annexed to, and exercisable within or about land. A general term for lands, tenements, and hereditaments. That's an interesting word. Property which, this is the part that I like, on the death of the owner, intestate, passes to his heir. That's why I like the term real property. Okay. So this is just a standard acceptance of deed. I'm sure you have, you've seen this already if you're looking at videos about acceptance of the deed. Another terminology, and I'm trying to hang on here. Let's get this situated so I can scroll down. Another thing that I have underlined here is fee simple. So let's look in Black's Law and let's look up what fee simple means, because this is why you're going to possibly get pushback from your recording office because of this little term, fee simple. So again, I have Black's Law 6th edition. Fee simple says, typically words fee simple standing alone create an absolute estate, and devisee in such words followed by a condition or special limitation creating a defeasible fee. This is from Babb versus Rand, ME 345 A2D 496, 498. Okay. So a fee simple absolute is an estate limited absolutely to a person and his or her heirs, and assigned forever without limitation or condition. So basically, fee simple is saying that this is your property, absolute, without limitation or condition, meaning that some, county can't come in here and say, you know what, you owe us property taxes, or you owe us, whatever, because that's a condition. Next part, An absolute or fee simple estate is one in which the owner is entitled to the entire property with unconditional power of disposition during one's life, and descending to one's heirs and legal representatives upon one's death intestate. Such estate is unlimited as to duration, disposition, and descendability. This is Sladen versus Hardin, 256 KY 68579 SW 2nd 11, 12. And it goes on with some even more explanation. And I would encourage you to take a look at your Black's Law Dictionary and really understand the words that you're using in your acceptance of the warranty deed. So at any rate, just to wrap this video up, some other things that we are doing in addition to the acceptance of the deed. We've already sent the mortgage company, and we're enforcing that as we speak. We've sent the mortgage company we tendered a note to have the actual mortgage discharge, so we're enforcing that as we speak. Also, the next information that's going to the mortgage company will go to the CFO, and basically using an administrative process to basically, they're going to default because they're not going to respond the correct way. And we'll have a contract in place that basically will state that we will, if they don't respond point by point with the information that's in that affidavit, we will, we're not going to wait for them to reconvey the property. We're going to reconvey it ourselves. And that's the power that we have, and you have as well. So we're going to do a deed correction for fraud, and we're also going to do a notice of revocation of power of attorney, and we're going to fire the trustee and put a trustee in place that we trust, a family member, loved one, someone like that. That's the way a trust is supposed to operate anyways. So anyway, I'll let you know. I'll give you some updates on that as things unfold. And that's it for now. So take care. Leave a comment if need be. Talk to you soon.